Good morning. Thank you all for joining. So our latest webinar series, our HR in half an hour. So we do these, try to get them in there every other month on the even month. And we have a guest speaker today, so very exciting. But just some housekeeping reminder that we'll have the recording of this posted on our website within a couple days. And we'll give you, whoever's attending here, we have a link to our slide deck. If you have any questions today, you can go ahead and put those in the Q&A feature. Should have that option. But just know this topic is more like general information. So there might be some things where you have to take away as like an internal business decision, or you may need to reach out to your actual employment attorney for specifics on your policies, but a lot of great information. So with that, I'll let Annie take it away. So we have Annie Kahn from Fisher Phillips. Thanks, Annie.
Awesome. Thank you so much, Kristen. I appreciate that. Well, hello, everyone. As mentioned, I'm Annie Kahn. I'm an attorney with Fisher Phillips out of our Irvine, California office. I'm a core member here at the firm of our privacy and AI practice groups, and I regularly consult on the intersection of these matters. And I hope that today you walk away with some useful information on AI and how that relates to California privacy laws. So with that, I do need to mention, again, this is not legal advice. Materials that are being provided for educational and informational purposes only, and again, do not constitute legal advice. But with that, let's jump in. So what I'm going to cover today is I'd like to go over the use of AI tools, how we're seeing them used within the HR context, the legal landscape, specifically in California, and then how to think about approaching balancing the use of these tools and the innovative technology that's out there and responsible use. So that's a lot, no doubt. So let's just jump right in. So why AI and employment law matters. So before I, talk through some of these examples, I want to just sort of set the stage. So we know that AI is rapidly changing the way businesses are operating, and these AI tools are becoming more common in the workplace. And with that, there come legal and ethical risks. And so those are also increasing and have to be taken into consideration. So we know a handful of states already regulate AI in certain instances, and we do expect that to increase over time and in the near future. So we do expect to see more legislation, more guidance with respect to management of these tools. And California tends to be a front runner in this area, as we all know. So, keep in mind that while you may be looking for standalone AI laws or regulations, AI is also regulated in state consumer privacy laws, and California's California Consumer Privacy Act is one of them, which I will talk about with respect to their automated decision-making technology rules. So, when making sure you want to stay ahead of the curve, ensure that the scope of laws that you're reviewing is not just the AI specific laws, but other areas where there are relevant laws that are going to dovetail into this, specifically like privacy, which we know is a big one. So in addition, many applicants and employees are also utilizing AI tools. So not only are we seeing it in the business context, but we know that in the consumer context, obviously it's being used as well. So that also presents new challenges for employers. With respect to these AI regulations, they're fairly complicated, and it really does take a village to review, analyze, and figure out your compliance. So teaming internally is really critical to effective governance and compliance with respect to utilizing these tools. And they also take time to review. So, if you think if the CCPA applies to you, for example, and you've got a few weeks before January 1, 2027 hits, you really don't have enough time. You really do need to start now and start looking at your internal operations, your service model, the systems that you're using, mapping all of that out, or all of the above. And consider that all of that may need to change, depending on, again, your use cases and where it falls under the law. And as we talk about AI, and I'm sure you've heard lots of terminology used with respect to AI utilization and tools, it's really important to understand the terminology. One, because it's coming out and it's changing ever so quickly, but depending on your use case, how that AI technology is built in, say, a third-party software is really important to understand. So as a general matter, there's no universal one definition of AI, but generally it's machines that are mimicking human intelligence. That includes speech recognition, decision making, problem solving, and language understanding. You'll hear generative AI used, which is creating new digital content off of data sets and deep learning. There's large language models, which is AI that is trained on massive amounts of text and data sets to generate human-like language. There's machine learning, where AI that learns from data to make predictions to perform certain tasks. And a hot button area that we're seeing a lot more of is AI agents, there's assistants, and there's chatbots. And that range, agentic AI can range from fully autonomous systems to simple task automation. So understanding the AI, the terminology, and what they all means is important to understanding then how it's incorporated into your business and then the tools that you're using. So jumping in, how are businesses using AI in the HR context? There's a lot of use cases that we see. So for example, we see it in resume screening and ranking, where you're matching keywords and validating skills to identify, a set of top candidates more efficiently. There's tools that can handle interview and scheduling that are analyzing video interviews for maybe sentiment or communication type skills. There's AI related tools that support performance management, employee training, that can help organizations identify strengths and areas for development. And one of the most impactful uses is predictive analytics, which we also see, where AI is analyzing data to identify employees who may be, for example, at risk of leaving, or sometimes what might be called a flight risk. So the systems can uncover correlations between turnover and factors like pay, training, opportunities. It can also be used for employee monitoring and productivity tracking. It can provide real-time insights into workplace engagement and various performance. So there's a lot, and this is a non-exhaustive list. There's a lot of use cases here with respect to AI. And it has a lot of benefits. These are just some potential benefits. There can certainly be more. It could improve efficiency and consistency within an organization. Again, you're getting data analytics. That could be very useful and insightful in terms of employee satisfaction. You get real-time feedback. There's different use cases in terms of the benefits based on the tool that's being used. However, with that, there are very important legal and operational risks to consider. So oftentimes there can be an over-reliance on AI, and that can lead to missed nuances that if there was a human in the loop, they might have caught something. And if that's not properly managed, AI systems can actually perpetuate or even amplify existing biases. So bias is a very big risk with the use of these tools. And they're not perfect. So they can also be inaccurate and provide non-existent information. So we hear about AI hallucinations all the time, and generated responses and other content. So, the data has to be reviewed by a human. There's significant privacy and data security risks. So, sensitive employee information, is that involved? Is that being utilized in the tool? Who is it being shared with? What are the is data being segregated appropriately so that, certain systems don't have access to sensitive data? A lot of systems might be lacking transparency, so then it makes it very difficult for a business to understand or explain how then the tool is being used and how certain decisions are being made. And if there's improper use of AI, that can clearly expose employers and businesses to significant legal liability, particularly if the technology itself is resulting in discriminatory outcomes or violating privacy laws. So, with the benefits, you have to weigh the risks that are also in play with utilizing these tools. So, what are some of the key risks then for employers when they're utilizing these tools, whether you're, again, thinking about deploying it or you're already using it? And again, this is a non-exhaustive list. So, again, it brings various benefits, but it creates a host of risks and compliance guardrails that need to be followed. So, poor data and flawed customization can lead to inaccurate or biased outcomes. So, we've all heard the phrase in different contexts, right? Garbage in, garbage out works in this context the same way, right? So if an AI system is being trained on poor or biased data, if it's not properly tailored to your organization, it can produce flawed or discriminatory results. And this can lead to violations of anti-discrimination laws at the federal level, at the state level, and the local level, to the extent that there's local laws that you also need to comply with. The AI tools can raise serious concerns, again, I mentioned around data privacy, surveillance, and security, especially when you're handling, and employers obviously are, very sensitive employee and applicant information. We have intellectual property and copyright issues if the system is generating protected content that you may not in fact own or that the system didn't actually have a license or authority to use. If it's being used improperly internally, there could be a potential loss of trade secret protection of a business's proprietary, confidential, strategic information. If that information is being input into, for example, a publicly facing system, a lot of those publicly facing systems are training on the inputs to train their model, and then they're also putting that information into the public domain with other outputs. And so, you might be potentially losing certain protections. You might also be waiving privilege or confidentiality. So again, you want to make sure data privacy and security is a real big thing. AI outputs can also expose employers to liability and reputational harm if, it's inaccurate or there's hallucinated AI outputs, and if that's not being checked. So, and this is also a non-exhaustive list of these risks. So, examples of these risks can, in real life context, include resume screeners that, for example, are unintentionally favoring certain demographics, or virtual assistants that are rejecting candidates based off of certain rigid or outdated criteria, or employee monitoring software that rates performance in ways that may in fact not even be legally defensible. So, you want to make sure that you understand the tool. You want to be proactive in identifying risks, and addressing them, and ensuring that any AI tool usage that you are using is compliant, it's fair, and it's transparent. So one of the other areas, not just with respect to, we think about compliance and following laws and regulations and making sure that, we're buttoned up under our legal obligations, but you also want to pay attention to litigation trends. So in this area, we're seeing a lot more litigation around AI bias and privacy. So litigation involving AI in employment is on the rise. There are lawsuits that are targeting both, bias in hiring tools and privacy violations related to workplace technology. So, for example, class action based on AI-powered screening tools, that's potentially having a disparate impact based on age, race, and disability. And it shows that both employers and vendors can face potential liability, even if there's no intent to discriminate. There's other cases that involve, again, AI bias hiring systems that are perpetuating racial bias. Other cases where AI transcription tools are note takers or recording conversations without proper consent and then subsequently using that data to train an AI model. So that raises concerns about an unauthorized recording, privacy violations, data retention matters. And even if a case is brought against an AI vendor, businesses should still be aware of pending claims. And so again, some of the key risks, as I already mentioned, disparate impact, vendor liability, privacy and consent violations, accessibility, union and collective bargaining, discoverability of AI generated records, and then that's just some of the key risks. There are certainly others as well. So what are some considerations for employers when you're thinking about deploying or having it's already deployed in your organization, and you're analyzing again the tool? So there are several. We know it's rapidly changing and it's already part of everyday life. So it's not necessarily a new concept. So for example, AI is used in navigation apps. It enables virtual assistants like Siri or Alexa to answer questions and manage various tasks. In the business context, we see companies using AI-driven chatbots for, customer service-facing communications. It's in supply chain management, marketing and content creation, AI. There's a lot of AI tools for that. So it's not new, but it is now changing rapidly how it's used in the HR context. And again, there's legal and ethical risks when you decide to deploy these tools. So you want to make sure that you're aware of what those are. There's lots of use cases and why it works, but with that comes issues. So you just want to make sure that, before you're deploying a tool, ideally, that you know what its intended use case is, how is a human in the loop, what are my compliance obligations, what laws apply to my business, and then making sure that you are buttoning up your compliance both internally and to the extent there's external notifications and obligations that you're providing those as well. So when we think about all the laws that employers need to navigate, we know that there are several. Again, there's federal, there's state, the local, but there's also different contexts, right? So if you're a developer of AI, or you're deploying AI, there's very specific obligations that you need to adhere to. There's AI specific usage in the employment context. I'll cover some of those under California law. Again, privacy and data security, can't emphasize that enough. Anti-discrimination, collective bargaining, employee surveillance, and electronic monitoring. There's intellectual property and trade secret, risks and analysis. And then if you operate globally, you have the global legal landscape to also adhere to and determine what applies to your organization. So with that, let's jump into California specifically. So at a high level, I didn't want to gloss over that there are many laws that impact employers. And as I mentioned, federal, state, local level, and then there's AI specific laws and regulations. And then there's also, business and industry specific regulations as well. So there's a lot of mapping and understanding that businesses and employers need to understand. And for example, in May of this year, California Governor Newsom, he signed an executive order directing California state agencies to start studying potential workforce disruptions that are caused by the use of these AI tools in order to protect displaced workers. And then provide through new policy recommendations. So there's a lot of moving pieces to this. And keep in mind that there are existing laws like Title VII, ADA that still apply, and there's also agency enforcement such as the EEOC or the FTC. And then we also have the state and local laws. So we're talking about California today, but if you operate in other states, you want to make sure that you are thinking about other state laws that might apply to your business. So there's AI related laws in New York City. Illinois, Colorado also has an AI law that's coming into effect. So you want to just make sure that you're not just paying attention to California, but to the extent other laws apply to you too, and then mapping that out. So let's jump into some specific California laws, excuse me. So the California Civil Rights Department updated regulations on automated decision systems, ADS. These became effective back in October 1st, 2025. It applies to employers or vendors that are regularly employing 5 or more individuals. And it essentially extended FEHA's anti-discrimination rules to AI and automated tools used in employment decisions in the employment context. And it holds employers accountable for discriminatory outcomes, even if it's caused by the third-party AI vendor. So you can't just point to the vendor and say it's their fault. Employers are going to be held accountable no matter what. And it applies broadly to all employment practices and requires that technologies used to screen or evaluate candidates be non-discriminatory. So under the CRD regulations, so what is an ADS? And you'll see different terminology. You'll see ADS, ADMT, AI-related technology, automated tools. A lot of the terminology might be different, but there's a lot of overlapping as well. So under the CRD regulations, an ADS is a computational process that makes a decision or facilitates human decision making regarding an employment benefit that's defined in the regulations. So an ADS can be derived from and or use artificial intelligence, machine learning, algorithms, statistics, or other data processing techniques. So that's where understanding the tool and AI technology is really important to understand how is the ADS system using data. And the laws also under the CAD provide some illustrative examples on what types of tasks an ADS can perform. So resume screening is specifically identified, and then using computer-based assessments or tests to make predictive assessments about applicants or employees. So it's really a specific analysis that really needs to be done in terms of what applies to you and how you need to comply with the regulations. So some compliance considerations for the CRD regulations that are in effect. So avoid discriminatory effects. It's going to increase record keeping requirements. So rather than retaining records for 2 years, it's now a retention obligation of 4 years. And this includes any data, ADS data, such as the information that's used in a system produced or customized for that ADS. Bias testing under the CRD regulations, it's not required, but it is recommended. So conducting bias testing, conducting ongoing monitoring, our human in the loop reviews is very much encouraged to demonstrate your compliance. And again, it's not mandatory under regulations, but evidence of bias testing can be used as proof of due diligence if there's a discrimination claim later. And lack of bias testing can also be relevant to those claims. So California Consumer Privacy Act. So this is certainly a biggie. These are the CCPA's new regulations on automated decision-making technology, so ADMT. So key dates for compliance here vary. So if you are using ADMT to make a significant decision, which I'll go over on the next slide, you need to be in compliance with the rules by January 1, 2027. So starting now is really critical. If you are going to be using ADMT to make a significant decision, excuse me, after January 1st, you just need to be in compliance immediately. There's no grace period for you to ramp up. The CCPA applies to businesses if they meet certain thresholds. I won't go into that, but if the CCPA applies to you and you're using AI or automated tools to make what they've identified as a significant decision, then these rules do apply to you. So what's an ADMT? Any technology that processes personal information and uses computation to replace human decision making or substantially replace human decision making. ADMTs include profiling that replaces or substantially replaces human decision making. So again, the threshold inquiries determine if the ADMT requirements apply, because not every utilization of an AI-related technology or tool will meet the threshold. So the threshold question really is it then making a significant decision about a California resident? So that's why it's important that you evaluate each tool independently and how it's operating. So some things to note under here. So substantially replace human decision making. That's defined as when a business uses a technology's output to make a decision without any human involvement. But to meet the threshold of human involvement requires that the reviewer, one, know how to interpret and use the technology's output to make the decision, have the ability to review and analyze that output of the technology and any other relevant information to make or change the decision. And they need to have the authority to make or change that decision based on our analysis of number two. So in order to meet these thresholds, there are very significant obligations on what you need to meet. So one thing I do want to note too is in terms of compliance on this slide, there may be certain exceptions on when one or more of these might not be required. But let's just talk about the compliance considerations with the CCPA and ADMT regulations. So number one, you need to provide a pre-use notice. So if it's your utilization is making a significant decision, you need to provide a pre-use notice. It informs consumers when the ADMT is going to be used, how it's going to be used, what the output is intended. There's a series of pieces of information that must be included under the CCPA. You need to provide an opt-out right. So businesses must offer at least two ways for a consumer to opt out of the ADMT use to make that significant decision. And one of those methods needs to match how the business is primarily interacting with that consumer population. So for example, if everything is done online, then there needs to be a methodology online that allows the consumer then to opt out. I do want to note, and I won't go into too much detail, but there are very certain specific exceptions on when an opt-out right is not required. One of those being there's a human appeal process that exists where there's someone with real authority who can review and overturn that ADMT's decision. If it's being used for very specific internal purposes only, and it's working for the business's purpose and it's not unlawfully discriminating based off of protected characteristics. So that comes up a lot. You also need to provide consumers with the right to access the ADMT. So this is where a business needs to provide consumers with information about the use when they're responding to that consumer's request with respect to the use of this ADMT. Under the CCPA regulations, if you are using ADMT to make a significant decision, if they apply, then you have to conduct a risk assessment. There's other obligations on when a business might need to comply with the risk assessment, but if you're using the ADMT in this way, you need to do this risk assessment. And this is where there's very specific requirements again under the CCPA, but you're evaluating the benefits to the business versus consumer privacy, and also cybersecurity audits. But I know we're running low on time, so I'm going to move a little bit faster. Again, this is a non-exhaustive list of California laws. So I also want to highlight AB 2602, which is the replica of voice or likeness law. This came into effect January 1, 2025, and it amends the California Labor Code, and there are protections for individuals from the unauthorized use of digital replicas of their voice and likeness. So there's very specific obligations surrounding this. SB 53, Transparency and Frontier Artificial Intelligence Act. This became effective on January 1 of this year, and there's new requirements for frontier AI developers. So this may or may not apply to you, depending on if you qualify under this particular regulation, but there's also requirements here for employers. And so just to wrap up, and I want to spend a little bit of time here. So AI compliance considerations. So, as I mentioned, you want to balance, utilizing this technology and its innovative use cases with responsible use. And the bottom line is that AI offers a lot of real opportunities for businesses, but it also brings, again, legal and ethical responsibilities and compliance obligations. So, number one, you want to make sure that you're staying informed, you're implementing robust compliance measures, and you're proactively addressing the risks, to making sure that you're leveraging this technology effectively, but also responsibly and remaining compliant in this very quickly ever-changing environment. So, what might that look like? So, we always recommend starting step one. So you want to map your uses of AI across the organization. Here we're specifically talking about, mapping your use of tools in the employee life cycle. So what does that mean? That means you want to identify which tools you're using, what's its intended use case, and does that trigger certain legal obligations? You want to map the inputs, the decisions that are resulting, the outputs, the data that's being used in the system, where the data is going. You want to review the vendors that are being that you're utilizing for these tools. You want to make sure that you understand the updates to the tool, the training data on the tool. So you want to keep, ideally, I'd recommend, one centralized tool registry so that you have a finite list of everything that's being used in the employee life cycle, and if it meets one or more of these obligations. Developing an AI governance system and team. So this is where, establishing a strong program is essential and can be key. So this is, setting up clear systems and safeguards for how AI is going to be deployed in the organization, what type of frameworks being used from a risk and security position, to define roles and responsibilities of who might be part of this governance committee, ensuring that there's human oversight of important AI-driven decisions, including regular reviews and checks, just to make sure that you're remaining in compliance. So there's some designing involved, there's defining involved, there's escalation paths to think about, providing ongoing training, tracking and evolving obligations. You want to regularly audit your tools for bias, accessibility, and disparate impact. Provide compliant notices to applicants and workers. Make sure that they're tailored for the tool and the decision, that you're explaining the output, the review process, access rights in compliance with the law. You want to make notices easy to find and then update them when the tool or the workflow itself might change. You want to conduct, again, risk assessments and update when things change. So you want to make sure that you're conducting the right internal risk assessments, and to the extent there's disclosure obligations there. For example, there will be under the CCPA, that you have those calendared and you understand what's going to be required in terms of what needs to be produced. Strengthening your cybersecurity programs. And training. You really want to make sure that training is a component of any AI tool utilization governance rollout. You want to make sure that employees understand the proper use, you have the right consent requirements in place, that you vetted your vendors. So let's talk about practical controls just at the end here. So you want to vet your vendors, certainly. So in addition to analyzing your internal operations where the tools are being used, you want to make sure that you are doing your due diligence on the AI vendor tools themselves. You want to make sure you understand bias audit rights, and you want to build in bias testing into contracts. You want to make sure that you have the information that you need from the vendor in order to make sure that you can comply as well, and you understand how the tool itself is being used. Providing human oversight over key decisions, as we've seen just a couple use cases, but you'll see this more, having a human in the loop. And where is that human in the loop in terms of the process that's being deployed? You want to maintain transparency with your employees and your candidates. And again, there's tons of operational benefits. to deploying this technology, but it's really important that you do so in a compliant and responsible manner, and you understand the legal risks in advance before deploying any such technology. And you have the ability to build an efficient and scalable program for your internal organization moving forward. And with that, right on time. So again, thank you everyone for joining. I'm happy to field any general questions. If there are any questions, of course, you have your MG team to reach out to as well.
Annie, wonderful. Thank you so much. It's a lot of information. It's really helpful as we're all trying to navigate. As you said, AI is not new, but certainly trying to figure out the best way to utilize all these expanding tools. That's a great word there. I haven't seen any questions come in, so we can go ahead and close out this session. Thank you all for attending. Reminder that this is part of a series, so we do have our sessions that are upcoming the rest of the year are available on our website for you to register now. So we will see you there. And the recording of this session will be posted out on our site early next week. So thank you all.